April 20th, 2021. Dear Mr. Speaker, I hereby advise you that I have returned without my disapproval, disapproved, and vetoed the following House bill to wit, House Bill 135 as amended in the Senate. I cannot in good conscience approve.
Gentleman from 22.
Thank you, Mr. Speaker. I ask unanimous consent that we dispense with further reading of the letter from the governor and enter that into the journal.
There's been an objection from the good lady from District 1.
I move that we dispense with further reading of the governor's letter, just have it entered into the journal.
Second is by lady from 23. We have a motion before us to dispense with reading the letter of veto. Is there debate on the motion? Lady from 1.
Thank you, Mr. Speaker. Would the good gentleman yield to a question?
The gentleman from 22?
Sure.
Will the gentleman yield? Gentleman yields.
Thank you, Mr. Speaker. Good gentleman. We seem to be reading all the other rants of this out-of-control governor. I'm just curious.
Good lady.
Or man on the second floor.
All right,
I'm
so we're
just
gonna keep
curious
our-
why we're not going to read this letter.
Gentleman from 22.
Thank you, Mr. Speaker. Frankly, I didn't want to hear it. And as far as I guess we could make that motion at any time on some of those. Anybody could make that motion. I'm not sure why this one's any different, other than we're probably going to have a robust debate about this very issue here in a few more minutes, and I figured that would be an appropriate time for this legislative body to take action as far as what we felt was right. There was a press conference that already went through all of this information. I'm not sure we need to read it again.
Thank you. Is there lady from 1? Is there further debate? Gentleman from 11.
Mr. Speaker, I believe we need to hear what the governor has to say. I didn't hear the press report, and I think in deference to the highest elected official in this state, we should hear what he has to say. He was elected by a majority of the people in this state, and as the representatives of this group, that group of people, we should hear what he has to say. So I think it's wrong to not hear what he has to say.
Thank you. Is there further debate? Good gentleman from District 28.
Thank you, Mr. Speaker. I've read a little bit of this letter, and I think it's very appropriate that we all hear it. I found it to be incredibly demeaning to the people of the state, and particularly to this body, and to get us properly warmed up for the debate. I think it's good that we hear the letter in its entirety, and I would encourage the clerk to read it slow and deliberate, because it's worth listening to.
Is there further debate? The lady from 1.
Thank you, Mr. Speaker. I'm kind of interested in hearing the letter myself, because I do understand the role of the governor and the role of the legislature, and our role is to make the law, and it is the man on the second floor job to enforce the law. And so I'm just kind of curious what all he has to say about how to make law. And ultimately, we're the ones sitting in these seats. So I'm kind of curious to the letter, not sure how I'll vote, but curious on what that's going to look like.
Is there further debate? Terry?
Mr. Speaker, I assumed I was doing the body a favor, but if people want to hear it, I'd be happy to ask unanimous consent to withdraw my motion on the ability to listen to the.
There's a gentleman.
my friends, thank you. With that, I'll just be quiet.
All right. Do you have the concurrence of the second? All right. Unanimous consent, right. We have a unanimous consent request to withdraw the motion. Is there an objection? Hearing none, the clerk may read.
Dear Mr. Speaker, I hereby advise you that I have returned without my approval, disapproved, and vetoed the following House bill to wit, House Bill 135 as amended. I cannot in good conscience approve any bill that will impair the ability of the governor to protect Idaho and its people from future emergencies, nor can I sign any bill that violates our constitutional commitment to the separation of powers. Like you, I swore an oath to faithfully discharge my duties and to uphold our Constitution. That is why I am vetoing House Bill 135 as amended, and why I vetoed Senate Bill 1136 as amended on April 16, 2021. The Idaho Constitution, like the U.S. Constitution, wisely divides the primary powers of our government between three co-equal branches. To the legislature, it gives the power to make laws. To the judiciary, it gives the power to interpret those laws. To the executive, it gives the power to enforce the laws. With those powers come sobering responsibilities. The legislature must be deliberate in its lawmaking. The judiciary must be fair in administering justice, and the executive must, above all else, protect the people of Idaho. Our Constitution prohibits each branch from exercising powers assigned to the other. It also forbids one branch from preventing another from performing its constitutional powers. These prohibitions are necessary to prevent tyranny that can result from absolute power by one branch. But there is also a more practical reason. No branch has the expertise and resources needed to effectively carry out all the duties of the others. Declaring and responding to emergencies are core executive functions, and our Constitution gives the governor broad powers to do what is necessary to protect the state and the people of Idaho. The executive branch has the resources and can tap subject matter experts in emergency response to quickly and effectively deploy resources in fast-moving situations. This last year has been difficult, but look where Idaho is today. Countless lives are saved, and we avoided a crisis in healthcare. I listened to the experts, and Idaho was one of only a handful of states with the fewest COVID-19 restrictions. We now have the strongest economy in the nation. I attribute our success to the spirit of the Idaho people. However, I cannot overlook the critical role played by Idaho's emergency statutes, especially Section 461008. These statutes are not restrictive on people's rights. Rather, they complement the governor's constitutional powers and provide additional resources and flexibility for the executive branch to do what is necessary to help Idahoans. We know future emergencies will include floods, fires, and drought, the routine experiences of living in the West. Unfortunately, it is also likely Idaho will face future multi-state disasters involving major earthquakes, enormous flooding, or devastating fires. We could experience a massive sustained power grid failure. The full list of potential devastating disasters is simply unknown. That is why any legislative changes to our emergency statutes must be done carefully and collaboratively to avoid unintended consequences that will harm the state's ability to act timely and effectively for the benefit of Idahoans in future emergencies. Regrettably, there are serious concerns with the process that led to House Bill 135 as amended. Numerous stakeholders felt ignored, including our National Guard, the cities, the counties, FEMA, state emergency managers, and businesses. Like Senate Bill 1136 as amended, House Bill 135 as amended poses a serious practical and constitutional consequences for the future. First, House Bill 135 as amended is overly restrictive and will handcuff the governor's ability to take timely and necessary action to help Idahoans during future emergencies. The bill will prevent a governor from taking steps unless it is essential to protect life and property. Imposing such a narrow standard will unwisely prohibit actions necessary to restore services and infrastructure and ensure the continuity of government, save jobs, help schools reopen, and protect the economy at large. For example, the governor will be unable to suspend regulations that impair agricultural and industry from operating or minimizing financial risk during a drought, flood, or other disaster. Nor will the governor be able to deploy the National Guard to take any and all action necessary following a massive earthquake, including but not limited to removing debris, repairing infrastructure, assisting businesses and government offices with reopening. House Bill 135 as amended, further prohibits the state as well as counties and cities from taking any action that limit the constitutional rights. Idahoans value our freedoms, and I agree that our constitutional rights can never be outright suspended, especially during emergencies. However, temporary limitations on our rights are necessary in some circumstances to effectively combat emergency conditions and to protect the greater good. For example, we need the ability to evacuate and cordon a town in advance of a dam break, even if to do so temporarily limits our right to travel, work, or assemble. This unqualified restriction will complicate efforts to save lives and mitigate emergencies, and will put public safety personnel at risk. This one common denominator of a disaster is that the no action or slow action alternative is unacceptable and not what our citizens expect and deserve. Second, House Bill 135 as amended unnecessarily politicizes the state's emergency response efforts and will jeopardize critical funding for local governments. Disasters often worsen and spread over time, requiring supplemental declarations and orders. Very few, if any, emergencies are extended solely for the purpose of receiving funding. Thus, the bill will more likely require the legislature to convene every 60 days to approve every emergency declaration with conditions or restrictions. In large-scale emergencies such as an earthquake, volcanic eruption, or attack, may not be physically possible for the full body of the legislature to convene or maintain a quorum. Yet House Bill 135 as amended provides no backup plan. This is irresponsible. On the other end of the spectrum, it will be unnecessary and costly to convene the legislature to extend smaller emergencies that impact only one or a few communities. If the legislature is unable or unwilling to extend an emergency declaration, the state will no longer meet the criteria to be eligible to receive federal disaster funding, nor will the governor be authorized to utilize the disaster emergency account, which is only available during a declared emergency. The change in House Bill 135 is amended, allowing disaster expenses incurred arising out of an emergency does not go to the necessary distance to make the disaster emergency account available after a direct declaration is terminated. I agree that there is a time and place for the legislature to be involved during future emergencies. That is why I came to the legislature early in this session and offered tangible solutions and a path forward. I encourage the legislature to consider appointing a small group of legislators, such as duly elected legislative council, to take on the role of representing the full legislative body when convening 105 members is impracticable or unnecessary. Further, the legislature was encouraged to explore legislation specific to statewide public health emergencies. However, House Bill 135 as amended was drafted, amended, and passed without seeking critical input or collaboration from my office. Third, House Bill 135 as amended violates the separation of powers doctrine and is unconstitutional. The bill limits the governor's constitutional powers to respond to emergencies as is necessary and to utilize the National Guard. It attempts to reassign to the legislature the core executive powers to extend and terminate emergency declarations and orders. House Bill 135 as amended also attempts to give the legislature the ability to determine the subjects of an extraordinary session, which is a constitutional power assigned solely to the governor in Article 4, Section 9. Finally, it is well settled that the legislature lacks the constitutional power to extend, modify, or terminate an emergency declaration or by concurrent resolution. Yet House Bill 135 doubles down on that legally ineffective procedure, further jeopardizing the state's ability to timely and effectively respond to future emergencies for the protection of Idaho, our people, and our livelihoods. We can do better. I remain willing and committed to working with all of you in the legislature to improve, modernize Idaho's emergency statutes, but we will need to involve all the stakeholders and focus on how any changes that impact Idaho's ability to respond to future emergencies. I am extremely grateful to the members of the legislature who have taken the time to hear me out. You know who you are, and I appreciate you now more than you know. I also urge my partners in the legislature who voted for House Bill 135 as amended to reconsider the votes on the override. It's time to get back on track. The people of Idaho deserve our best. Sincerely, Brad Little, Governor of Idaho.
All right, House Bill 135 as amended in the Senate will be held at the desk. The question before us today is shall House Bill 135 as amended in the Senate, the governor's veto, shall the House pass House Bill 135 as amended in the Senate, the governor's veto notwithstanding? The debate is open. Gentleman from 22.
Thank you, Mr. Speaker. Appreciate the opportunity to open this debate. I've kind of debated amongst myself there. Interesting conversation when you do that. As far as how I should approach this, should I spend time going through the bill and all of the rationale and reasons why we got to where we did, or maybe just to address the letter that we just heard, or maybe to discuss, I think, why it's important that we, as a legislative body, support legislative actions. And I don't know what the right answer was, but maybe I'll touch on a little bit of all of those. So I do want to at least touch on what 135 does. I think it's important that we kind of are reminded what the purpose of House Bill 135 was. House Bill 135 protects the separation of powers, does not grant the legislative body any additional powers. In fact, it protects those powers. It indicates that all jobs are essential. Nothing was more offensive to me than being told that your job was not essential, but somebody else's job was essential. Putting food on the table at my house, that's pretty essential. And I think that's for everybody. Their jobs are essential. Otherwise, they probably wouldn't be doing them. That's why it's called work. It put a limit on how long disasters can run. Can't just run forever. Emergency declaration can't just last forever. Now here's the big rub. Everybody says, well, but we've got these declarations that have lasted for years in order for us to be able to repair roads or move roads or to take all these preventative actions. You're right. Those are important. And that can happen under House Bill 135. Same provisions, same opportunities still exist within that to be able to receive federal funds, resources, and benefits to be able to address that emergency. Clarifies that the executive branch cannot make laws. That's in here. I think that's important. And it protects the constitutional rights that we have. Now, I've always kind of thought that was interesting that we said that we're protecting your rights within a bill. Those rights stand long before this bill was ever written. Those rights are there. And whether I say it in this bill or not does not change that. You have constitutional rights. They don't go away. Let me talk a little bit about what we just read there. If I can now find my notes, my letter that I just buried. Oh, there it is. Sorry. Maybe I'm glad that letter was read. It gives me a great list of talking points to go down here, and I won't address them all. But Mr. Speaker, letters, is this appropriate to read directly from, being that it was just read, or do I need to ask unanimous consent for that?
I think that's an interesting question. For sure, we can do it with unanimous consent.
I'll just ask unanimous consent to be able to read from the governor's letter.
Without objection,
Thank you, Mr. Speaker.
one may read from the governor's letter.
Quite a few lines here that I liked. The Idaho Constitution, like the U.S. Constitution, widely divides the primary powers of our government between three co-equal branches of government. To the legislature, it gives the power to make laws. I like that. To the judiciary, it gives the power to interpret those laws. I like that too. To the executive, it gives the power to enforce laws. Enforce. The Constitution prohibits each branch from exercising powers assigned to the others. We were assigned the ability to write the laws, and then yet later on it says we might need, during an emergency, the executive branch might need to change those laws. Wait a minute. He just said that our Constitution prohibits each branch from exercising powers assigned to the others. Well, that's what I think 135 does. It says we make the laws, you get to enforce them. Section 461008 talks about where were these powers derived from. In fact, in the letter that I mentioned, it said the constitutional powers solely assigned to the governor in Article 4, Section 9. Well, let's look at Article 4, Section 9. See what that says, and Article 4, Section 5, Article 4, Section 4. Supreme power is vested in the governor. Supreme executive power of the state is vested in the governor, who shall see that the laws are faithfully executed. The laws are executed. Doesn't say you get to make laws. It says you can faithfully execute those laws. As far as where's the ability to respond to the emergencies, you've got a governor as the commander-in-chief of the militia. He shall have the power to call the militia to execute the laws. Why does he need the power for the militia? To execute the laws, to suppress insurrection or to repel invasion. I did take a little bit of umbrance there, I guess, when it says here that I came to the legislature early in the session and offered tangible solutions and a path forward. I've spent a lot of meetings in joint leadership, and we asked help us get to where we want to. In fact, it was almost a little embarrassing how much some of my friends were begging, help us get to the end. This is where we need to get to. Help us to get there. In silence. That's very upsetting to me to say that we did not try, didn't ask. Asked more times that I was embarrassed that we asked. Says that House Bill 135 prohibits the state as well as other counties and cities from taking any action that limits a constitutional right. I want to read that again. It says House Bill 135 further prohibits the state as well as counties and cities from taking any action that would limit a constitutional right. Well, good. That's what it's supposed to do. You don't get to limit our constitutional rights. Now, I'm not saying there aren't limits to constitutional rights, but I'm saying that you don't get to go ahead and make those arbitrarily because a disaster was declared. Says that can't activate the National Guard. I'm going to have to go through this bill because I'm pretty sure we took care of that in many sections.
Point of order.
Lady from 1.
Thank you, Mr. Speaker. As we go through this letter, it would be really helpful if I could have a hard copy in hand, and I wonder if we could just take a 5-minute recess and just get a copy in front of all the members.
Are you going to look for me?
I'm good with that.
Well, I can put the House at ease for that. I think that if the debate is going to turn on the points made by the gentleman's letter, then I think it's proper that you have it in front of you. You could probably access it on your computer someplace, but we will get a hard copy for you. The House will be at ease for the time necessary to do that. The House will be in order. Prior to going at ease, the House was in the 4th order of business, and we were in the process of the opening debate on the question of overriding the governor's veto on House Bill 135 as amended in the Senate. The gentleman from 22 was interrupted in his opening debate by me, and he has the floor to finish.
Thank you, Mr. Speaker. I think the point I was at next was another comment there on the letter. It says, nor will the governor be able to deploy the National Guard. That was said in the letter there. Let me just point you to the language in the bill. 46-1008, subsection 2, subsection E. Nothing in this section hinders the governor's ability to activate and use the National Guard to respond to a declared emergency. I don't know how you could interpret that to say that you can't deploy the National Guard. Nothing in this section hinders the ability. So what else is in here that I've not talked a lot about as far as the powers that are in here in the bill? Because we focus on kind of the changes, but let's look at some of the things we did not change. Subsection 4, during the continuance of any state of disaster emergency, the governor is the commander-in-chief of the militia and may assume command of the National Guard forces available for emergency duty. To the greatest extent possible practical, the governor shall delegate or assign command authority by prior arrangement, embodied in appropriate executive orders or rules, but nothing herein restricts his authority to do so by orders issued at the time of disaster emergency. Go down, it says he can suspend the provisions of any rules prescribed for the procedures for the conduct of public businesses, can utilize all state and federal resources available to the state, including but not limiting to, list there, transfer the direction, personnel, or functions of state departments and agencies or units therein for the purposes of performing or facilitating emergency services. Subsection D, subject to any applicable requirements for compensation under these sections for other things. Subsection E, direct and compel the evacuation of all parts of a population from any stricken or threatened area. Wait, direct and compel the evacuation of all or part of the population from any stricken or threatened area. That's here. Can do that. prescribe routes and modes of evacuation. Also, subsection D, control ingress and egress to and from disasters. That's in here. Can even suspend the sale of alcohol for a little bit of time. That's in here, if you cared about that. There are a whole litany of things that can be done within House Bill 135. Everybody's been focusing on what did we take away? Well, that's all there. House Bill 135 was worked on not in a vacuum. It was worked on by a lot of people in this body. I'm very appreciative for the help and work that they did on that. I could start listing off quite a few of the representatives, and then I would leave out somebody, and then I'd feel really bad that I did that. But it was also not just worked on by the House. Every change that we did on this, I personally met with Senate leadership and went over every one of those changes. Are you good with these changes? What do you think of these changes? And we walked through that process. This was a collaborative process. We came up with a good bill. We had a good vote. Now, I wasn't really planning on going through that list of what we read on that letter. I was going to talk about the good things in the bill. But the last thing that I do want to talk about just briefly has nothing to do with the bill. Nothing to do with the gentleman on the second floor. It has to do with the legislature. Now, I know some of you didn't like this bill from day one, and you voted against it, and that's okay. I understand it. You have your reasons. I have my reasons, and I will not question your reasons. You had good reasons. I know you did. You were doing what you thought was best, and that is perfect, and that's what you should do. I'm not asking you to change your reasons for voting against the bill. I'm not. I would ask you to consider, though, that the legislature passed this. We passed it on the House. We passed it on the Senate with a significant margin. So what I'm asking then is maybe for you to consider, if you would, supporting the action of the legislature. Not asking you to go against the gentleman on the second floor, not asking you to go against your original reasons for voting against the bill. I'm not. You had good reasons, and those are fine. But we as a legislative body made a decision, and we passed it. So maybe as a reason, I'm giving you a reason why maybe you could support the override if you didn't before, is to support the legislature. Now, if you don't, that's okay too. I get it. I'm not here to criticize anybody's decisions. We all have our reasons why we do things. But I'm at least trying to give you at least an excuse maybe to where you could support us there. I will answer any questions to the best of my ability if you have any on this. Other than that, I know there'll be some other people who want to talk about this a little bit, but I would encourage your green light on this.
Thank you. Gentleman from 11.
Thank you, Mr. Speaker. I think it comes as no surprise that I won't be supporting the bill. I've voted against it every time. So, and one of the primary reasons I voted against this bill is because it can deal with one single incident. This is not with this bill, it can apply to a rock slide in Elks that closes the road to Elk City. That emergency declaration was open for 4.5 months. And so are we going to let the people of Elk City hang out there because we can't get them food or water or whatever they need? Or are we going to come back and make those decisions on what happens at Elk City? Is that good use of the taxpayer dollars? I don't think so. Secondly, technically speaking, on line 15 on page 2, subparagraph B, talks about receiving federal funds. Well, that's great. I'm glad we're keeping it open to receive the federal funds. But who disperses those funds? Are we going to be called back to have to disperse those funds? We don't want non-cogability for the governor's office. The gentleman on the second floor's office, pardon me, Mr. Speaker. And so how do we disperse those funds? They're going to just sit here at the state. Not only that, but there's no guarantee we'll get those funds. There's a lot of things that have to happen in an emergency before you can apply to get reimbursed. And that's what you do. You apply to get reimbursed. You don't automatically get the funds. So that, and then line 40, where it talks about, the legislature can extend it for 365 days. Well, to me, that looks somewhat contradictory or confusing to me, because I'm thinking, okay, does that mean that the legislature is the only people that can extend an emergency for 365 days? So then do we have to be called back again to extend an emergency for 365 days? And as you all probably are well aware, many of these emergencies last for years. So those are the reasons that I'm against this bill. And not only that, but you've heard some emotional testimony, and right now there is a lot of emotion because of the situation that presented itself with this pandemic. And people are upset, which is okay. I mean, hey, we all get upset. But making decisions based on emotion is never good. Reasoned decisions are what we should always be making. And when we make decisions in legislation, we don't always get them right. How many times have we come back and had to redo something in a bill? So I think we should sit on this, and we should be deliberate about this. We have interim committees for silly things, or not silly things, but for various things that aren't as important as this. But we haven't done that with this, where we're trying to limit some powers. Maybe there are some things we need to change. I really appreciate you listening to me. Thank you, Mr. Speaker. And hopefully you'll take those points into account, because I don't think this is a good use of taxpayer dollars.
Thank you. Is there further debate? Good gentleman from District 17.
Thank you, Mr. Speaker. I passed out a handout, and there's actually 121 pages to this handout. And I'm happy to share it. I've shared it with the good gentleman from 21 and anybody else that wants it. And what that is a list of all the declarations of emergencies that the Secretary of State has on file since 1957. And you can see the first couple of years, they don't have a lot, but at any rate, that's 63 years of declarations of emergencies. There's about 7 per page, which means that there have been about 900, and this is approximate, it could be 1,000, declarations of emergencies by Idaho governors in the last 63 years. And if you divide 63 into 900, that's 14 per year. Some of these are continuations of declarations of emergencies. Some of them are initial. And one of the reasons that you have so many is that the different counties apparently have to go through a process and request the declaration of emergency. So if there is flooding, you've got different dates of requests, and you have an uneven, you have a different expiration of the 60 days that's proposed in this legislation. In other words, if there's a major disaster, I got a feeling we're going to be real busy as a legislature if we have to come back in 60 days. And some of these declarations are, well, for example, on page 3, there's 2 for Clark County for relating to excessive snowpack. This was in 99. Not sure exactly what that was about, but at any rate, some of them seem to be of less significance than others. Like many of you, I got a letter from the food producers, and they point out that in their letter, they point out that in 2017, there were 5 disasters declared, that 3 of those 5 declarations would have passed the 60-day time limit. So, in addition to the logistical problem of the 60-day limit, and there's a concurrent resolution for 365 days, I'm not sure, in view of the different legal opinions we've had, whether that would be enforceable or lawful, but at any rate, that is in the bill, and I'm not sure where that goes. But there can be little question that what this bill does is bring this legislature even closer to being a year-round legislature, and I don't think the people of Idaho want that. The problem with the legislature acting is that acting with regard to these disasters is illustrated by this bill. This bill has been discussed since August. Since the August special session, and I think the concepts were even discussed at the in my State Affairs Committee, joint committee that was appointed to consider election legislation. It's been 100 days, and now the bill finally got to the governor. The legislature can't act very quickly. That's the point. It's been a very slow and deliberative process, and a good process. The gentleman from 21, he has worked really hard. He talks to everybody and tries to get consensus. He's one of the best people at doing that in this group. But the problem is that takes a bunch of time. It takes a bunch of time to talk to 105 people and get a majority to agree to something. It's a structural problem. It's not a personal problem. It's not that we have people that are so disagreeable that they just want to argue all the time. It's a structural problem. Legislatures aren't designed for executive action. This country learned that back in the 18th century. In the 18th century, we had a government, the first government of the United States, called the Articles of Confederation. And the states all met and they had a cumbersome procedure where they would make decisions by majority rule in this Articles of Confederation quasi-legislature. It was based on the Continental Congress, except it was a little more sophisticated with rules, and they ran into problems with foreign policy, and they ran into problems with the national policy. And in 1789, it was agreed we need an executive branch to run the national government. And if we don't like the executive branch, we need a way to remove them or from office. And so the President of the United States position was established, and there were elections established every 4 years. And, of course, George Washington was our first president. Legislatures are not designed to deal with disasters. That's the problem with this bill. Therefore, I ask for your no vote and I ask for your vote to sustain the governor's veto. Thank you.
Thank you. Good gentleman from District 32.
Thank you, Mr. Speaker. I've heard that we need to deliberate on this. Here we are past the year mark on this so-called emergency. So we had deliberated for quite some time. So have our constituents, so have Idahoans. They're fed up. Why is the executive branch so afraid of shared power? What's the real reason? Yes, we heard in the speech that the Constitution would be violated if this were to go through. Let me address that. Article 4 of the Idaho Constitution delineates the governor's executive branch's powers. 20 sections of that Constitution does not mention emergency powers anywhere in that section. None. Section 3 of the Idaho Constitution addresses that power. What is Section 3? That is our power. Article 3, Section 22 states, when acts take effect, no act shall take effect until 60 days from the end of the session, at which time shall have been passed, except in case of emergency, which emergency shall be declared in the preamble or the body of the law. Emergencies are addressed by us, but by making law. Therefore, the Disaster Preparedness Act that was passed a while back is unconstitutional. We didn't have the authority to give our power to the executive branch. We didn't have that authority. Now we want it back. Scratching and crawling to get that power back. Why did we give it up in the first place? We need to take it back today. My constituents and Idahoans are fed up with the overreach during this whole process. My constituents had their lives overturned, businesses shut down, couldn't go to church. Their God-given rights restricted because of this overreach. I saw it in impeachment, as all of you know. I take these constitutional violations very serious. I got grief for it. That's okay. That's my principles I stand by. I asked the body across the rotunda to do what's right. Stand for Idahoans and not the executive branch for once. I'm tired of being beholden to the executive branch. With our own power, with our own body, let's do what's right for Idahoans. This letter mentioned tyranny. I don't believe any of us are tyrannical in this body or the body across the rotunda. The only tyranny I've seen is from the executive branch the past year. I'm done with the reckless violations of our citizens' rights. Vote to override this. Thank you.
Is there further debate? The lady from District 1.
Thank you, Mr. Speaker, and I do appreciate getting the letter in front of us, and that's the first I had heard that letter, so I definitely wanted to go through it. And there's so many issues I have with the letter, I will spare you. I will spare the body. I will just mention one concern in the letter is these are not constitutional rights. As the gentleman on the second floor mentioned over and over again, these are God-given rights to life, liberty, pursuit of happiness. And so there's many other issues in the letter, but I will address that in a different outlet. I want to touch on what this gentleman from District 33 just said. We aren't tyrants in here. And it's really, really hard to be a tyrant when you're a 1 in 105 vote. It's really hard. But it's easy if you're just one person. And that's why I think we really need to override this bill, this veto. We need a rebalance of these powers. And when one person can declare an emergency, and then they can decide what happens during that emergency, and they can make unilateral decisions on everything and every agency during that emergency, and then that one person can determine to extend the emergency for as long as possible, and we're going on over 1 year of a declared emergency. Unilateral decisions are why I think we need to override this veto. we do need a check and balance in this system. And I also don't like that during this unilateral decision-making, the letter referred to greater good. Who determines greater good? I thought we all represented our citizens. We came here, we passed laws, we discussed them for the greater good. For one person with unilateral decision to make an emergency, determine what's the greater good for a public for over a year, it's outrageous. And it's hard to stand up for things, but this is something I believe our body really needs to do, is stand up against tyranny, I'd say at this point. So I'm urging you to vote yes on this.
Thank you. Is there further debate? Gentleman from 13.
Thank you, Mr. Speaker. To debate in favor of the override.
You have the floor.
Thank you, Mr. Speaker. And to read from the governor's letter, I think that that's already been established. We can. Here's my concern and what the the gentleman on the second floor said. House Bill 135 further prohibits the state, as well as counties and cities, from taking any action that, quote, limit a constitutional right. Idahoans value freedom, and I agree that our constitutional rights can never be outright suspended, especially during emergencies. It was only a year ago, Mr. Speaker, that our constitutional rights were outright suspended. The right to assemble, or the right to exercise our religion, which is in the First Amendment to the Constitution, was outright suspended. In fact, this issue was argued before the United States Supreme Court with regards to the state of California, and the Supreme Court agreed that you cannot limit that constitutional right. He goes on to say, however, temporary limitations on our rights are necessary in some circumstances to effectively combat emergency conditions and to protect the greater good. If this individual feels like that constitutional rights can temporarily have limitations placed on them, and he did with regards to our First Amendment, what about our Second Amendment? What if we have a governor who is very anti-Second Amendment? If this is the line of thinking that we subscribe to and we think is okay in the state of Idaho, we have a major, major problem. As I read the First Amendment, it says that our First Amendment rights cannot be abridged, which means curtailed or diminished. Yet that's exactly what happened a year ago in this state. And our Second Amendment rights cannot be infringed. Mr. Speaker, I'm very concerned that this is the position that the executive branch is taking. And I think the only way that we can push back is that we can override the executive action on House Bill 135. It was very clear the intent of this body and the august body across the rotunda that we wanted to ensure that constitutional rights were never limited, were never temporarily suspended for the greater good. Our founding fathers had the wisdom to recognize that governments have the ability to continue to take away liberties a little bit at a time. And they said, you know what, these rights, those constitutional rights, can never be abridged or can never be infringed upon. And yet that happened in our state. I am extremely disappointed that that happened in our state, and our citizens expect our action to protect their constitutional rights and to ensure that this never, ever happens again. And so I'd ask that you support the motion to override.
Thank you. Gentleman from 16.
Thank you, Mr. Speaker. To debate. Here we are on day 101, and debating this veto ain't much fun. The gentleman on the second floor wants us to pursue this issue once more, but I think I'm just ready to be done. We are in day 101. This is the third longest legislative session in our state's history. And we have proven, regrettably, that we are not nearly as nimble as the gentleman on the second floor to respond to an emergency. If something goes cattywampus in our state, we need to act nimbly and expediently. This body is deliberate and deliberative, but we are neither nimble nor expedient. Our process is working right. However, to perform the actions of the executive branch, those actions, in my opinion, belong in the executive branch, and I'll be voting to sustain the veto.
Is there further debate? Gentleman from 30.
Thank you, Mr. Speaker. Just a quick, I hope, clarification and explanation. These things have already been referred to, Article 4, Sections 4 and 5 of our Idaho Constitution. These are the places where the governor is given what might be termed emergency powers. Those emergency powers are limited to calling out the militia, to execute the law, to suppress insurrection, or to repel invasion. The governor is recognized as the supreme executive power, is vested in him, and that supreme executive power is to execute the law. There are no other emergency powers in the Idaho Constitution that I can see. The emergency powers that the governor has otherwise are in statute. We have every right to modify those statutes and to better clarify the emergency powers of the governor. So, excuse me, the gentleman on the second floor. So near the end of the letter where it says, the House Bill 135A violates the separation of powers doctrine and is unconstitutional, as near as I can tell, that simply isn't true. There is no violation of the separation of powers doctrine. We have the right and the authority to define in statute what further emergency powers we grant to the governor, and we have the right to change those things in statute. It also says in the letter the bill limits the governor's constitutional powers to respond to emergencies. I think we've already clarified that can't be true. His powers in the Idaho Constitution are very limited, and this bill does not limit those powers further. This is an issue of statute and our right and authority to modify statute. I will vote to override the veto and urge all of you to do the same.
Thank you. Gentleman from 10.
Thank you, Mr. Speaker. Requesting unanimous consent to refer to other legislation.
Without objection, gentleman may refer.
Thank you, Mr. Speaker. I supported this legislation both times it came before us before. And there's one specific area of this bill that motivated me to do so. And that's located on page 4, lines 29 through 30. I felt that it was concerning that election statutes could essentially be rewritten and reassigned without any legislative action. And so I do agree with the gentleman on the second floor's letter in the separation of powers conversation that the legislature legislates. That having been said, I can also understand the frustration and the feeling among members of the body, particularly around those election laws, that maybe the balance of powers had become a bit cattywampus. And that many of the directives coming out from the gentleman on the second floor were as random and unexplained as the KTVB tweet about Mark Johnson last night. But I'll be voting against the override, and I'd like to illustrate that just a bit. The Senate concurrent resolution we passed recently the 101 days blend together, I don't remember how recently, that would submit to the people a ballot question of whether or not we should be able to call ourselves back into question is something I take seriously. It's very important, and I don't feel that most of my constituents, save for perhaps a handful of the loudest, feel that we have done a good job of trying to think through all of the potential emergencies out there. There is a growing narrative, and we are not without fault in assisting in that narrative, that we are more focused on the balance of powers than we are on the underlying policy areas. With regard to that conversation, we have a particular role, and I'd like to be just a little self-revealing here and admit something that's a little uncomfortable for me to admit in such a public forum. I am a Dallas Cowboys fan, and I have been for 30-some years. And I recall when the owner fired the coach after the second consecutive Super Bowl. Even though I was in high school at the time, I read an article by a sports writer who apparently prophetically predicted that the dynasty and domination would end with the last second penalty in the Super Bowl for 12 men on the field, and the 12th man would be Jerry Jones. Well, it's our job to write the playbook. It's our job to call in the plays. But as much as it may be uncomfortable, it's the executive branch's job to run the plays. To the degree this addresses the issue of rewriting statute, I only wish that was all that this did. But whether it's the High School Activities Association or any other method of taking over executive functions, we're not doing ourselves any favor in pushing back on the narrative that we're overly focused on the powers of the legislative branch. Now, let me say that it's the struggle for those powers between the branches that make us a nation and a state of limited government. The executive can't get too strong so long as the legislative is struggling against it. The judiciary is reliant on both the executive and the legislative, and the legislature can't get too strong so long as the executive is struggling against it and the judiciary is checking its work. It's a good thing. This struggle, this argument is a good thing. As for page 4, lines 25 through 28, I'd like to address some of what the good gentleman from 13 had to say about the limitation of rights and what the good gentleman on the second floor said about that. First of all, this language protecting the manufacture or use of firearms that is in the bill there is pre-existing language. So while I understand the good gentleman from 13's point, the specific example of a threat of an incursion upon the Second Amendment is not cognizable under existing code. But secondly, let me submit that your First Amendment rights are currently being limited by the fact that the Speaker has recognized me to speak. There are limitations of time, place, and manner on absolutely every right we have. And I really like how on line 23, the wording there is, or enforce any additional restrictions. And I suppose if it said, or any additional limitations, or any unreasonable limitations, I might be able to live with that. If it specifically called out the free exercise of religion, I would probably be okay with that. But I do see the good gentleman's point in pointing that out. As for the constitutional balance of powers, the Idaho Constitution, for as robust as it is in comparison to the United States Constitution, much of what is inherent in each office or each branch's duties isn't well defined. You will not find in there the state treasurer or the state controller or the attorney general even what their scope of responsibility is. It's not there. The way those are found are in looking at what they call constitutional core functions of each office. What did the framers in 1890 believe they were granting when they created those offices? For example, a constitutional core function of the Attorney General's office is to represent the state in court, because it was well understood that was the job of an Attorney General. So while I respect and normally quadruple question myself before ever disagreeing with the good gentleman from 30, there are powers inherent in every executive office that are not well spelled out, except for perhaps the superintendent of public instruction after some subsequent amendments creating the Board of Education. So while I respect the struggle, while I respect our need to right the ship in some regards, this particular bill will not get my override vote, and I would urge you to vote no.
Is there further debate? Gentleman from 22.
Thank you, Mr. Speaker. Just debate briefly in favor of the override. I'm just amazed by the number of people that want to say, we've been here 100 days and now we're considering this. We've been considering this all legislative session. It shows the value of input from 70 members on this side and 35 on the other of how you come to good legislation. It's not just one person's idea, draft a bill and make everybody agree and follow it. That's what we have with the gentleman on the second floor. He gets to make one decision by himself without any input from the legislature, and then we all have to abide by it. It's much better if the body here and the other side, sometimes not, but agree and pass good, solid legislation. This bill has been worked on from the beginning of session. It's not an idea that's popped up this last week or day 99. It's one that started on day one. Actually started probably 6 months before day one. And so to sit here and say, well, we've been here 100 days and now we're talking about this. No, we've been talking about this all along. It's time that we, as a legislative body, exercise our oversight of the executive branch and stand our ground as the representatives of the people of the good state of Idaho. And there may not have been too many disagreements that we had with the gentleman on the second floor and some of what he implemented, and there may have been others. But his absolute refusal to invite the legislature to be part of the discussion is what was the most frustrating part for me. It was like, no, I've got absolute power. I can do all this, and you can't. I don't even have to call you back into session to discuss it. I can spend all this money that the federal government gave me without asking you any of it. It's time that we, who also have the appropriations, that we actually appropriate the money so the money that we get is spent properly. And so I would urge you all to vote to override the governor's veto. Thank you.
Thank you. Good gentleman from District 31.
Thank you, Mr. Speaker. I would ask unanimous consent to be able to refer to other legislation.
Without objection.
Thank you.
May refer.
Mr. Speaker, good ladies and gentlemen, today is a time for action. A lot has been debated. I'm not going to reiterate, but I do want to have my sentiments heard and recorded. I want to talk about this legislation and Senate Bill 1136. Monday was a welcome to politics moment for me as a freshman legislator when 1136, which I view as kind of a companion to this legislation we're debating today, after having passed this body with a veto-proof majority and having passed the body across the rotunda with a veto-proof majority, having been vetoed, failed to override that veto in the body across the rotunda. This legislation that we're debating today is similarly situated. Senate Bill 1136 was good legislation. It was good when we passed it with a veto-proof majority. It's good today. The current legislation we're debating is good legislation. It was good when we passed it with a veto-proof majority before, and it's good today. The powers that we're debating are inherently legislative powers. They are lawmaking powers. They are money-spending powers. There is no traditional executive branch power that we are limiting in any way through this legislation. Now, I am asking that we, as this body, have some fortitude, and I'm asking that we have some backbone. And I've said it again, and I've said it before, and I will say it again. No good comes from putting too much power in the hands of too few for too long. Let's override this veto.
Is there further debate? A good lady from District 31.
Thank you, Mr. Speaker. To debate in favor of the veto override. And my appreciation to my colleague from District 31 who just spoke. I fully support what he has said and what many of the rest of you have said. I would just like to share some thoughts briefly about some of the narrative that has developed around this bill. Specifically, I would like to speak to the idea that this is somehow an emotional, knee-jerk reaction. As has been stated by some of our colleagues, this particular issue of emergency powers has been discussed robustly by all of us on both sides of the rotunda since at least August and probably before. I would also remind you that midsummer last year, we were begging to be involved and to be a voice for our constituents back home in this process of handling an emergency. Admittedly, it takes time to go through this process. This is not a knee-jerk reaction, and I think it's unfortunate, inaccurate, and unfair to categorize it that way. Now, there's another rhetorical tactic that is happening here, and that is the tactic of instead of talking about the issue, we turn on the messenger and we attack the messenger. And I've heard that in a lot of the rhetoric that's been going around. And specifically, I hear a lot of attacks on the legislature as a body and as a part of our political process. I would ask you, what is it that makes us unique as Americans? What is it that protects our freedoms as Americans? There are many other systems of government around the world and throughout history. They have executive branches. The most efficient form of government is a tyranny, and there are many strong executive forms of government around the world. There are very few who have the opportunity and privilege of living in a country where the people have a deliberative representative process. And we should not shortchange the people back home by allowing this representative body and this legislative process to be disparaged and demeaned. It is our privilege and our heritage as Americans, and I would just remind us all of that as we continue forward with this discussion. I fully support the legislation that's come forward. I was part of discussions with our Office of Emergency Management way back last fall. We have had very robust discussions about how this legislation would play out in different emergencies. I read our entire state Office of Emergency plan. We talked about how all of these things would play out. We put forward ideas. We evaluated those ideas. We ran them past a bazillion people. We altered them. We drafted them. We printed them. We changed them. We redrafted, and we printed again. I would encourage you to support the result of this representative process and ensure that we maintain the strength of our representative voice going forward. I never want, again, as a representative or any representative anywhere, to find ourselves without the ability to exercise that voice in a situation when our constituents are pleading for relief. Thank you so much, and I urge your support of the veto override.
Is there further debate? Hearing none. Lady from 33.
Thank you, Mr. Speaker. Friends, there's been a couple things said that is quite interesting to me. And so I'd just like to touch on them. First of all, when we think of the deliberative process of the body versus one person, we purport to say that whomever that one person is, that they would always make the right decision. And I certainly won't argue with the fact that there have been many good decisions. And then there have been others that maybe decisions with which we don't agree. But to purport that one person is that person to make that decision, and then the other suggestion, stakeholders. Who are the stakeholders? Well, I purport to you that every stakeholder supposedly mentioned is also a member of the state of Idaho. They're a citizen, which means that if they reside in the state of Idaho, that you, my friends, and me, represent them as the stakeholders. So the stakeholders are represented by us, and we are their voice. And I know I said this twice before, and I'm just going to say it one more time because I think it is incredibly important to remember. As those of you who are considering maybe voting no, consider this, that you may be agreeing, and I understand, with many of the things that have been done. But I suggest to you what happens should your governor be another governor. And it could happen on both sides. Should your governor be that man who resides in California and took away all the freedom, the lady who resides in Michigan and took away all the freedom, or the governor that resides in New York, not just took freedom but caused deaths.
Mr. Speaker, I have to object to the denigration of public officials across America.
I have not denigrated anyone, Mr. Speaker. What I have done is suggested that they could be the governor here. And if that be the case, do you not want a recourse? I'm suggesting to us that we do. And with that suggestion, I'm asking you to vote to override this. Thank you.
Thank you. Is there further debate? Gentleman from 27.
Thank you, Mr. Speaker. To debate against the override.
Have the floor.
Thank you, Mr. Speaker. I'd like to address a couple of the points that have been brought up. The first is this idea that somehow my constitutional rights, either under the state constitution or the federal constitution, have been violated. I don't know about the rest of you, but none of my rights were violated at all, nor did I ever feel any of them threatened. I take my ecclesiastical orders from the Diocese of Boise and Rome. My religious rights in the United States weren't violated whatsoever. They happened to agree that there was a real issue with the pandemic, and they happened to agree that assembly of a congregation of people for any reason whatsoever was a threat. So my religious rights weren't threatened whatsoever, nor were any other of my constitutional rights threatened. Now, my life was, in some manner. I'm not a spring chicken anymore. Have some underlying medical conditions. So should I have happened to contract COVID-19, I don't know what would have happened. May not have had much of a problem, or may not be here today. But the fact is, that's where the real threat came from. I voted against this initially, and I'm voting against the override. And I think the number one principle for me is the following. It's the same exact principle of why there's a single commanding general on the battlefield. There's not a committee of generals, or there's not a pair of generals. A group of people cannot make immediate decisions. And in emergencies, you have to make immediate decisions. You can't have more than one cook in the kitchen. That doesn't work. And so I'm going to vote against this override. I would encourage all of you to vote against the override. And the reason is that legislatures are deliberative bodies. Every one of us knows what's happened here for 101 days. We've got another, I don't know how many days, 14 days, 21 days left before we're allowed to go home. This will wind up being the longest session in history. And I think we're going to be judged on this. And the people in the state of Idaho are going to stand around and saying, is that who we really want making decisions in an emergency for the state of Idaho? I think not. I'll be voting no, Mr. Speaker. Thank you.
Is there further debate? Good lady from 35.
Thank you, Mr. Speaker. I debated, I thought in my mind whether I was going to stand and debate, but when the good gentleman from 27 made a few comments, I guess I, on the other hand, did experience some changes, some limitations to my rights. I remember as I was preparing to run for office last year, many of us had things planned for how we were going to further our campaigns, and then we had a big change in our election date and the manner in which it was done. That's something that I think the legislature should have some say in, as we witness some things that happened across the country with different legislatures and governors. So I just think it's really, as I read through this, I just really disagree. I have a very different point of view than the gentleman on the second floor, and so I would encourage you to think about the things that have occurred in the past year and the limitations that you each have experienced, and vote to override this. Thank you.
Is there further debate? Good lady from District 11.
Thank you, Mr. Speaker. To debate in favor of the override. Thank you. So in 1866, the U.S. Supreme Court voted unanimously, 9-0, that the Constitution could not be suspended in the case of an emergency. And actually what they said is that in an emergency, the Constitution actually is when it's most needed. I can't imagine, like many of you, you had to have heard from your constituents over the last year plus, people calling and emailing and asking what they were supposed to do because they weren't considered an essential business. How were they supposed to work? Why couldn't they go to church? Why couldn't their kids go to school? Why couldn't they travel? Couldn't see their families? There were many, many things. What were they supposed to do to vote? How were they supposed to do that during the May primary? What was supposed to happen? There were numerous violations of the Constitution, in my mind, in our state. Now, granted, it wasn't as bad as what other states may have experienced, but for the state of Idaho, I was baffled that we were doing the things that we were doing, and the legislature had no input in what was transpiring. I thought that was asinine, and I couldn't imagine that the good gentleman on the second floor would not include the legislative body to be making these decisions. I couldn't understand that. And I remember being on many, many phone calls, being muted, not being able to say anything, and listening to what we were going to be doing without any input. And that was not right in my mind. And I had to talk to my constituents and explain to them that we wanted to participate. We wanted to be involved in this process, but we were unable to to do that at this time. And they kept asking, what is the legislature doing? Why aren't you doing anything? And that was my answer. We aren't able to. Our hands are tied. There is nothing we can do at this time. We had a nice little assembly, though, of 15 of us that came to the Capitol at the beginning of the summer and met together. We met right into the middle of the floor here and discussed. And we had at least 100 people sitting up there watching what was transpiring. They wanted to have their voices represented. They wanted us to hear them. They wanted to be acknowledged for what was transpiring in their lives, that they were being limited on what they were able to do, and they wanted representation. We do not have a king. We do not have a king in the state of Idaho that dictates to us what our rights are. Those rights are given to us by God. And it is up to us to represent our people and to listen to them and to speak for them on their behalf. That is what we are elected to do. And so we need to support this. This is a representation of us that we will have to go back to our constituents and say, we heard you. We are doing what we need to do to represent you. And we know that our ability is through our Constitution and through the powers that we've been given to be able to protect our rights, to protect the rights of our citizens, and to be able to maintain a balance of government. And for that, could I just quote from something very, very quickly? Can I have?
Unless it's the Constitution or the statutes, you've got to get permission.
Okay, may I have permission?
From the
Unanimous consent.
lady's asking as consent to quote from something. So we're going to go with you and trust that the something is a great source that'll.
It is an excellent source.
You have the floor to quote.
Thank you. So I mentioned the case in 1866 by the U.S. Supreme Court. And 30 years prior to that, Daniel Webster, who had argued over 200 cases before the U.S. Supreme Court and served as Secretary of State under 3 presidents, he stated this: "It is hardly too strong to say that the Constitution was made to guard the people against the dangers of good intentions. There are men in all ages who mean to govern well, but they mean to govern. They promise to be good masters, but they mean to be masters." And so I will just leave you with that, but I ask for your green light on this. This is for the people. Thank you.
Thank you. Is there further debate? Good lady from 8.
Thank you, Speaker. I'd like to read from the sine die report from 2020, please. I'm asking unanimous consent.
Without objection, the lady may read from the sine die report.
Thank you, Speaker. The Senate adjourned on March 19th. It was a Thursday, sine die. We were March 20th, 2020. That was Friday. It says in the closing days of the 2020 session saw the legislature's work continue under emergency declarations issued by the president and the governor to combat COVID-19. The social and economic impacts stemming from COVID-19, including state and federal responses to the pandemic, were largely unknown at the time each chamber adjourned. And so everyone who was here, you remember cases started happening. Blaine County had a big, large number of people that were being served for the COVID. And a lot of the rural areas in the south and north, they weren't being affected near as much. So a lot of us stayed. We wanted to stay. In fact, a lot of us didn't even want to sine die on that day. But what's interesting, and I think what really shows intent in the inability for the communication flow to have been somewhat better, is the fact that the following Wednesday, 5 days after we packed up out of our Airbnbs or hotels or motels or whatever, we went home and the governor declared at noon at the National Guard headquarters that we are on lockdown. None of us knew anything about it. I mean, I truly don't believe any of us knew anything about it. So on that day is when all the Cisco trucks were out delivering groceries to the restaurants to serve food that weekend. We're talking thousands and thousands of dollars, but you all didn't hear about that. But we did if they were calling us and saying, you're not going to believe how many perishables I just had to throw away. or when the hairdresser or the dog groomer or what have you, but it was really the restaurants who felt the impact that Wednesday. It's like, what? We've got to shut down? We just got our delivery of lettuce and tomatoes at the back door of the restaurant. We didn't know anything about it. And then a few days later, I remember that I had called the Secretary of State, our good man from second floor, whatever floor he's on. Anyway, when I called him and I said, we are still going to hold the election and the absentee ballots will be going out on April 4th. No, don't think so. Think we're going to move the election date to possibly August. I said, excuse me, August? So I don't know how many of you in this body, and I know all of you new freshmen weren't there for this, but it's like, no way. And I will guarantee you, every one of you and you freshmen today, there is no way you would want to walk out here and campaign for 4 or 5 months for a primary. You are ready to get back to your lives and get back to work and start mowing the grass or whatever you do. But I thought, are you kidding me? And then when you look in our state constitution, it's the legislature who determines the election date, not the governor. Thankfully, our speaker, good man from District 27, helped us out and made sure that that election date was held for May 21st. Then all of a sudden, a few weeks later, you know what, we're going to change it to June 2nd. We didn't do it. The legislature didn't do it. The governor did it on the advice of the Attorney General's office. That was wrong. We should have been consulted. I don't know how I would have handled an emergency like this if I was governor, but I would sure like a lot more input or consult from all of us with so many different varied backgrounds. It would have definitely warranted a bigger discussion. But we were totally ignored. The good lady from 11 mentions that during the summer we were on these phone calls, which I think a lot of us appreciated at first. But then if you remember, the goalpost kept getting moved. So many deaths per 100,000. Oh no, now the emergency room, the beds we don't have enough. And I mean, they kept moving. And then I think a lot of us just started tuning out because it really didn't matter what we had to say. The decision had already been made. We need to be able to provide input because we are on the ground listening to our constituents who are suffering. The essential, the non-essential, the loss of a business, the loss of a home, the loss of a job, the inability for your kids to go to school. Everybody was concerned. And if you don't think this isn't the biggest issue and that we need to rightfully take back our place in as a legislature and represent our folks, we have got to override this veto. We've all been listening to this for a full year, except for the freshmen. And I'm telling you, I'm sure you've heard a lot from your constituents already. Just magnify that to the 10th power for the rest of us. So anyway, I would really appreciate your yes on the veto override. I think this is very important. We have to help our folks out, and believe me, they will not forget this vote. They will not. Thank you.
Thank you. Is there further debate? Lady from 14.
Thank you, Mr. Speaker, ladies and gentlemen. You know, as I've reviewed and read and reviewed this letter, there are over a dozen references to Constitution, constitutionality, our constitutional duty. In those dozen references, not a single one refers to what I consider the most sacred duty, the most sacred constitutional duty that the people of the good district of 14 have elected me to do, what our people in the state of Idaho have elected us to do, and that is to protect their constitutional rights. House Bill 135 simply inserts that which is missing, even when we are attending to emergencies, and that is the constitutional rights of the people that we represent. The letter concludes that we can do better, and we can. by inserting the people's constitutional rights, even when we are working to protect their physical lives. Those constitutional rights should reign supreme. And with that, I would urge your green light in protecting those rights.
Is there further debate? Gentleman from 22, for what purpose do you rise?
To debate a second time, Mr. Speaker.
Does anyone, and I'll take a point of order here. With this, the override debate, there was neither an opening nor will there be a closing. So the gentleman was asked to be able to debate the second time, which we will let him do if there is no one that wants to debate it for a first time. Is there anyone that wishes to debate for the first time? Gentleman from 21.
Mr. Speaker, I'm new to this process and I'm new to this body. But what I'd like to say is, had I been part of this body at the initiation of this, I would have liked to had some input into what had transpired. And having been, hearing of this silented phone calls and so forth, I would like to point out an example that we heard in committee. For instance, we had a budget request for additional funds to protect and salvage daycares. And part of the reason why the daycares were struggling was as a result of the policy, which seemed to not have as great a concise thought process in shutting down businesses in the first place. And I'm a proponent of the free market, and had I had input into that process, I would have questioned the randomness of which we just declared certain businesses essential or non-essential, and we would have had a deliberative process about the unintended consequences of those kind of decisions. We would have certainly had an additional conversation regarding public health policy had I been consulted through this process. And so I'm in favor of, allowing the opportunity for this body to weigh in when it should be weighing in and getting the totality of the different perspectives, and maybe been able to blunt some of the unforeseen side effects of decisions that were made. So I also ask for your green light on this.
Is there further debate? Gentleman from 22 for the second time.
Thank you, Mr. Speaker, and I will try to keep this brief. I know we've heard a lot of this already, and I respect everybody and their decisions and their opinions on this matter, but I did want to at least address some of the concerns that were brought up on that. One of the concerns was does this work for other disasters? We've been looking at this through this myopic lens of a COVID, and what was interesting, and during every conversation that we had about this bill in those groups, was specifically asked that question: will this work for another emergency, not just this one? And I think, looking at those open declarations that were referenced by a couple of the good gentlemen, I think from 14, good gentleman from 17 talked about open declarations or ones that last longer than 60 days. They're absolutely right. There's plenty that have, and there's plenty that would, and House Bill 135 allows them to continue to move on. What's important to understand is current language allows declarations to last for 30 days. Current language. That's it. We're saying 60 and can be extended. So I think that is taken care of. As far as being able to spend monies, appropriate monies, whether or not we receive it or not, that comment was brought up. The powers that allowed the gentleman on the second floor to spend $1.25 billion without us still exist today. Not been changed. There's nothing that's been changed on that. So if more money comes in, still would be able to do that irrespective of any changes to House Bill 135. Over the last 63 years, roughly 1,000 emergency declarations. How many times were laws changed? I've not been able to find any. I didn't go quite back 63 years, but I did go back 15, and I didn't find one example where laws were changed prior to COVID. So I think it's okay that we say that you can't change laws without us being able to do our ability. Can we act quickly? Now that's an interesting question, I think, because what you have to look at is we've been here for 101 days. Seems like a long time, seems like an eternity for us. How many pieces of legislation have we considered? Not one. We're not talking about just one emergency that we're looking at. This body, on the House side, this is bills that have actually been introduced, have bill numbers, over 400 pieces of legislation. Now, how many drafts have gone into getting to those? If you've ever done legislation, you know it takes a dozen to get to just to a bill to be introduced. The Senate's done over 230 in 100 days. That's a lot of work that we've done. What did we do during the special session that lasted 2.5 days? We had 11 pieces of legislation that were introduced. We had 2 resolutions that actually passed. We had 3 laws that were passed in a very short period of time. Yes, it does take a long time for us to do certain things, but we can act quickly. We've proven that we can act quickly, and I think that's something else. The good lady from 31 had mentioned that we'd been asking over the summer to be involved in the process. I remember a letter going out, and I did ask the Speaker if I could refer to his letter. I'm not going to read his letter, but just refer to the fact that he sent out a letter back in April begging, keep us involved in this process. I personally sent one in June, personally asking, we encourage you to allow the legislature to help spend the $1.25 billion that's coming in. We asked. Were rights suspended? That's a question, were they? Well, I know a lot of churches who thought their rights were suspended. In fact, the Roman Catholic Diocese of Brooklyn, New York, thought his rights were being suspended and sued Andrew Cuomo, governor of New York, because they thought their rights were being suspended. Longest session in history. Why is this the longest one in history? One, we got a lot of issues to deal with, but we're here for this length of time because we were not allowed to participate during the summer. Had we been allowed to participate during the summer, I think this would have been a much shorter session. Had we been allowed to participate in the summer, I wouldn't be standing here before you saying the legislature needs to be involved when we have these crises. Remember what the current language is. Look at what the existing language is. It allows for rapid response from the gentleman on the second floor to respond to emergencies. None of that has changed. We extended the length of which the declaration actually will exist. It was 30 days. That's current language. We're just saying if you're going to extend it beyond that, then we need to be involved, but only if you're going to change the rules. How many times were rules changed prior to COVID? Not very many. Again, in my research, I found like very few references. It was one having to do with garlic production and such. So, can the executive branch respond to emergencies? Absolutely. Can those emergencies last for years and years? Absolutely. The language allows this. Again, I appreciate and understand the consternation that some of you have had with this bill from day one. I get it. I'm not here to twist your arm or anything else. But I am asking to support the legislative decision that we have made as a body. Thank you.
Thank you. Is there further debate? Hearing none? Then the debate is closed. The question before the House is, shall House Bill number 135 as amended in the Senate pass, the governor's veto notwithstanding? Now let me explain here for just a second. Because it requires 2/3 of the members present to override. And we won't know that until we do the count and do the math. And so it's not 47 votes. It is a 2/3 of the member present. I believe we have 69, 68, 67. That's why we'll pause before I announce. The clerk will unlock, so the yes vote has the effect of overriding, a no vote does not. The clerk will unlock the machine and the members will record their votes. Does any member wish to change his vote? The clerk will lock the machine. So there's 67 members present. 2/3 of that number is 45. More than 45 having voted in the affirmative. The House Bill 135 is amended in the Senate, has passed the House, and will be the governor's veto notwithstanding. The bill will now be sent, along with the governor's veto message, will be transmitted to the Senate.